In this video, we're going to talk about what might happen and what you can do if you find yourself convicted and sentenced of a motoring offence in your absence without you knowing. Yes, it can happen. You might find yourself committing an offence of speeding, the police sending you out notification, the court sending you out notification of the proceedings, you don't receive them, the case concludes with you knowing nothing about it. Indeed, the first thing you might know is checking your DVLA driving record and seeing penalty points that you knew nothing about. You might find yourself receiving a notice of conviction and sentence from the court and instruction that you've received a fine, or indeed the bailiffs might be knocking on your door telling you that you need to pay money for a court fine. Well, what happens if you find yourself in that situation? Because of course, it would be very unfair if you were convicted and sentenced of something that you knew nothing about. Well, in the first instance, if you don't have any knowledge of the proceedings, if the proceedings conclude without you being aware of them, you can make what we call a statutory declaration that you were ignorant or didn't know about those court proceedings. Now, the way that works is that it can be made before either a magistrate's court or indeed it can be sworn before a solicitor. Now, which of those options you take very much depends on how critical the time factors are. It must be said that swearing a statutory declaration before a court can, in modern times, take quite a long time, and even in some courts, a number of months, whereas if you swear your statutory declaration with a solicitor, it may be significantly faster. But what is the effect of the statutory declaration and what is it? Well, the statutory declaration is just a sworn document saying that you didn't know about the proceedings. The declaration must be sworn in front of the solicitor or the court and must be made within 21 days of you finding out about it. And indeed, if it goes beyond the 21 days, the court may refuse to accept the statutory declaration without another good explanation as to how that has happened. But once that statutory declaration is sworn, once it's accepted by the court, it has the effect of nullifying your conviction and sentence. So effectively, it wipes out any fine, it wipes out any penalty points. In some case, it might even be wiping out a disqualification if you were disqualified in your absence. What happens then? The proceedings, the charge, it doesn't magically disappear, but effectively what it does, it takes us back to square one. At that stage, you would receive the original notice of the proceedings and you would have opportunity to respond to the charge. Now, that might still mean entering a guilty plea to the offence, but having your opportunity to mitigate or minimise the consequences, or it might be that you haven't committed the offence at all, in which case you enter your not guilty plea and you then move off towards trial. In other cases where you've been disqualified from driving without knowing about it, it might be that you find yourself moving on to make an application to the court not to be disqualified. For instance, if you are disqualified for having too many penalty points, you might make an application to the court for exceptional hardship. So that is option one. If you're convicted and sentenced without knowing, you can make an application to the court for a statutory declaration. Now, the second option would be an application to reopen. This is slightly different in the sense it might be that you've missed a court hearing, you might have initially known about the proceedings, but then forgotten about the trial, for instance, and not attending court, and they've convicted and sentenced you in your absence. In that situation, we can make what we call an application to reopen the proceedings in the interests of justice, and if the court accepts that there's a good explanation, a good reason why you didn't attend court, again, the court can exercise a power to effectively strike out, set aside your original conviction, sentence, whatever it may be, and effectively take us back to that starting position. The final point would be an appeal to the Crown Court. If you find out about your sentence within 21 days, you can lodge an appeal to the Crown Court, and then the case can go on through the appeal process there. It has to be said that quite often the Crown Court would be the least favourable of the options because effectively you're denying yourself the first bite of the cherry in having your case properly heard at the magistrates court. But it is nevertheless one of the options. So in summary, if you find yourself convicted and sentenced in your absence and you didn't know about the proceedings, you can make a statutory declaration swearing to that absence of knowledge, and the conviction and sentence can be cancelled and effectively we start again. If you find yourself convicted and sentenced in your absence, but you knew about the proceedings but perhaps forgot about a hearing, we can make an application to reopen those proceedings in the interest of justice. And third option would be an appeal to the Crown Court. So finally, if you find yourself in this situation, if anything that I've said is of relevance to you, if you find those penalty points, if you've got a fine, if you've been disqualified and don't know about it, always best to speak to a solicitor. You can certainly contact Caddick, Davies solicitors. Other solicitors are available. Get some advice, find out what your options are, and try and rectify the situation.